Good morning all and welcome to the Bank of Mum and Dad. There are many of us in this room that may have already acted as a bank of mum and dad, and some of us that have this to come. It's been another year of sluggish wage growth, meaning that home ownership is out of reach for many prospective buyers. We want to do all we can for our loved ones, and therefore parents, families and friends will put up a massive £6.5 billion this year to help their loved ones onto the property ladder. That's a 30% increase in last year. That money will support up to 300 property purchases. Statistics have shown that the Bank of Mum and Dad rivals the UK's 9th biggest mortgage lender. So today, Dennis, Kate and I are going to be talking about this subject. So as a quick introduction to us all, Dennis is a financial advisor from AJ Life and covers all aspects of financial advice, including advising on mortgages, mortgage protection, investments and pensions. Kate is a solicitor on our wills and probate team and advises on wills, lasting powers of attorney, court of protection work, administration of estates and grants of probate, and I am a family solicitor advising in all aspects of family law. So before we start, a little bit about Palmer's. Palmer's was founded in 1983, and we do have one of our founding partners here today, Clive Tant. Palmer's is a leading law firm with a total staffing complement of around 120 people, and we assist a wide range of private and commercial clients, covering the whole spectrum of legal advice. Palmer's has 4 offices, all based in Essex. Our main office is in the Basildon area, and we have 3 further offices in Southwood and Ferrers, Chafford 100, Thurrock and Rayleigh. There are various Palmer's people dotted around the room, so if anyone does have any questions at the end, can we just have a show of hands of the Palmer's? Thank you very much. So I'm now going to hand you over to Dennis.
Good morning everyone, my name's Dennis Copping. I'm an old Palmerian and an independent financial advisor, or IFA, from AJ Life. What's an IFA? Well, basically, I collect all relevant information about you and then fit the best products from the market to you. I act as your agent, no one else's. So the Bank of Mum and Dad, does that make you all bankers and responsible for the 2008 crash? I'm sure it doesn't. I'm going to talk to you today about the money part of this. I go over the issue of deposits and saving, where money disappears, how to stop it doing so, how you should try to target the amount of deposits and the difference, I'm good at this, and the difference it can make. I'll talk about lenders, how they view gifted deposits, and what they want to find when they search for your child electronically. I'll touch upon the idea of buying a shared ownership property where the payment is part mortgage, part rent. Lastly, the issue of protection, home insurance, life, and various health insurances. Generally, when people talk about the Bank of Mum and Dad, they're referring to a gift of a substantial sum of money to a child, now a young adult. I call them children because when do they stop? To enable them to buy a house. For some of you, this may follow their university education, which led to them gaining a degree, 2 very proud parents, and an apparently large loan. I'll talk a bit more about student loans later though. Why is this gift needed? Apparently, it's impossible for youngsters to save money these days. I know this because my father told me after I arranged the mortgage for my niece. I calmly told him that he'd changed his tune. When I was young, my brother and my sister, I don't remember him saying, "Oh, go out and spend your money, I'll bail you out." It was the opposite. You save. You want something, you save. When I bought my house, yes, it was £21,000. What a lovely price. But my fiancée and I only earned £4,500 a year between us. So saving a deposit of £2,100 was very, very difficult. I had to go and work in a pub. Has its moments. So I suggest to you bankers that actually it's not impossible to save money. It's only as easy or as difficult as it has been, but does usually involve giving things up or finding alternatives. Maybe make your gift conditional on your children's saving. Maybe make the gift on a 1-for-1 or a 2-for-1 basis. A client of mine agreed to do this for their son. His partner's parents agreed the same. I was talking to the son, who I've known for about 20 years, and asked about his latest holiday. He said, "Oh, I haven't been away." I said, "Why?" He said, "Well, you'd be really proud." "But I'm not your father." I said, "No, but I've known you a long time." I said, "Well, okay." They decided not to use £2,000 of their savings to go on holiday. So I asked why. He said, "Well, it actually cost £6,000. Our 2,000, my mum and dad's 2,000, and her parents' 2,000. See how this works? With luck, you can change long-standing behaviours. Just say, you save 1,000, I'll give you 1,000. You save 100, I'll give you 100. How can children save? Everything is so expensive these days. It's so hard for them. I go to see many young adults and talk about what happens in the mortgage process, how much they can borrow, what the repayments will be. I always ask them to have their latest payslip and 3 months bank statements. Once I was proudly told they had £1,000 saved. How long did that take? Oh, about a year. Well, that will cover the legal fees then. Almost. I asked to see the bank statement and looked at his first. Found a Monday and went through a typical week concentrating only on their expenditure during a working day. It's quite easy these days with debit card transactions because it says so-and-so this much and they're in order. So I asked, "What's this £5 to Starbucks?" "Oh, I like to drink a cup of coffee on the walk to the office from the station." "All right, okay." "What's this £5 to Costa?" "Well, I like a coffee mid-morning." "Doesn't your employer supply this?" "No." "Okay." £15 to M&S? "Oh, it's lunch and a drink." £5 to Costa? "Coffee for the walk to the station." "Oh, right. Is this a typical day?" "Yes, apart from Friday." "Why?" "Well, I don't drink coffee on a Friday walking back to the station. I go out to the pub with my mates from work." "Oh, right. How much does that cost then?" "Well, I don't really know." So, okay, quick look at the statements. Average, £150 a week. "Do you drink £150 of alcohol? That's what, 25 pints?" "No, I put my debit card over the bar and drinks are bought." "Do you think some people take advantage?" "Yes." I turned to his girlfriend. "Are yours the same?" "Yes, but only £50 on a Friday." So here we have 2 city workers. His salary is £60,000, hers is £40,000. They want to buy a house for £425,000. Between them, in their time from leaving home in the morning to return in the evening, they spend, in a typical working week, £490 on, not a lot really, £25,476 a year. I think that's worth repeating, just under £25,500. I don't ever tell anyone off, it's not my place. I do like to suggest a controversial idea or two though. We all like a good cup of coffee and we all like a decent sandwich. So, controversy. Week 1, buy a coffee machine each. Get an espresso. If you like good coffee, get a decent machine. Leave it at work. Costs £100 a machine. This saving money? Stick with it. You get £50 free coffee for each machine. Take capsules with you. Then in the morning, no queuing for a Starbucks coffee. I'm not sure they actually use coffee in their brown drinks, but, you know. Walk straight to work. Enjoy a lovely mug of coffee for 40p. Also buy a reusable mug. Coffee mid-morning, make one. Coffee anytime, actually, make one. In the evening, put it in your mug and drink it in the walk to the station. At the weekend, go to the supermarket and buy a loaf of bread. And your favourite filling. If it's best cheddar and ham off the bone, buy it. I reckon you could have top-notch sandwiches for £15 to £20 a week. Yes, go out with your mates from work. It's important, team building. Keep your debit card in your pocket. I know it's a hard thing these days. Set a limit of £30, that's what, 5 pints? When I was 18, a pint was 12p. The saving just by doing those really complicated things, which to me, if you want to buy a house, are really simple, is 400 a week, £21,000. So if you match 1 for 1, that's 42. If her parents match 1 for 1, that's £63,000. Now, I'm not saying you should give your children £21,000, but maybe if they save that much, you might have to give them £5,000 or £6,000. Then, other things like only drinking bottled water. I saw a couple in July, it's crackers this. They asked if I would like a drink. I said, oh, I'll have a glass of water, please. It was a really hot day. So he went to the fridge and after a bit of rummaging and throwing a bit of lettuce on the floor, said, we haven't got any water. Oh, no, I said. Haven't you got a tap in your kitchen? Their reply was, what, you drink tap water? I said, well, yes, actually. Can you really taste the difference? Then, of course, we have £40 for a Chinese takeaway that takes no longer to cook yourself than it takes them to deliver it. The big difference is it only needs to cost you £10 instead of 40. An easy one for you is when your children start to talk about owning a property, is to say, well, when you own a house, you have to pay your mortgage, your council tax, your electric, your gas. You may even need some food. So what, £1,500 a month? So save that each month to get used to it. So in 6 months, they'll have 9,000. In a year, they'll have 18. And see where this is going. I know we'll want the best for our children. I certainly do. But if we as parents don't encourage them to curb their spending, who will? Because actually, it's so much easier for me if you just say, don't worry, little Johnny, we'll give you the deposit. Then, wow, I haven't got to do any hard work. Well, much. While we're talking about deposits, or at least I am, I must tell you it's important to target them. Lenders change their mortgage rates in 5% bands. That says 10. They lend money on a 5% deposit, but the rate is much cheaper if you get 10%. Santander's 5-year fixed is 4.04 with the small deposit and 2.49 at 10%. So if that's a £200,000 purchase and they have a deposit of 18,000, a lot of money, the rate is 4.04%. The payment on a 30-year mortgage is £873 for the first 5 years. If they can save £2,000 in the 3 months it takes to go through, then the rate's 2.49 and the payment is £710. Saving of £163 a month for 5 years, £9,769 less. Actually, thinking about it, you could do the mortgage over 25 years instead of 30. Then there would be savings £66.50 for 5 years. So £3,990. What's the point of that? That's not so much. And then another £52,386 because you pay the mortgage for 5 years less. Admittedly, with inflation, that has an effect, but money's money. However, if they can't do it, they can't do it, and you just proceed on the smaller deposit. When I bought my house, and also the one I'm living in now, the normal mortgage term was 25 years. In recent years, we've seen this become longer as house prices have risen. For first-time buyers, 30 years is normal, and 35 is not exceptional. A couple of years ago, there was talk about 50-year mortgages, and the popular misconception, unfortunately, was that it would be half the cost of a 25. Well, unfortunately, 25 years is 806 on the previous example, and the interest only on that is 373, so 50 years is 524, so I don't think it's worth it. Lenders, oh, I love them. I don't really. They all have their own little rules. But when it comes to gifted or part gifted deposit, they're all the same. They require you to confirm on a letter or their standard form that the deposit is a gift, not a loan. There will be no repayments and you will not have an interest in their property. Surjit will explain what is meant by having an interest in a property. Where will you get the money from? Well, basically there are two places. It either comes from your savings or from borrowing, maybe a remortgage. If from your savings, all well and good, but maybe have a word with your IFA and just say, where should I take the money from? If you're thinking of cashing in a pension under these new rules, please don't, because you could pay a massive amount of tax on it. If by remortgage, maybe get the IFA who's dealing with your child's purchase to sort out a remortgage with you. Now, on the subject of lenders and mortgage application, and especially for parents and any children that are here, well, I suppose we're all children, it is very important that all of your children's address records are at the property they live in. That includes bank, credit card, payslips, P60s, driving licences. They must also be on the voters' roll where they live. If they do not register at their address, you must not keep them registered at yours, unless they live there. I realise it's a nuisance having to change addresses, but not so much of a nuisance as having a mortgage application completely straight declined. They wouldn't do that, those lenders, would they? Oh yes. Recently, a client was declined because there was no record of him at the address he was living in, no record of his credit card at any address. He told me to liaise with his mother, so I asked her, why is this? She said, well, because I have everything sent to my address, because if anything goes wrong where he's living, he'll come back here. I said, oh, right, okay. I said, well, that's really interesting, so change all of the addresses and get the credit card at his address, and ask them how long it will take to go to on the credit record. Because of this problem, I asked him for 2 years CIS vouchers, like a self-employed payslip. And guess what? Yeah, you've got it, another address. So make sure they take care. Nothing to mum and dad's home or girlfriend's mother's if they're living somewhere else. Bit like the Paul Young song, wherever I lay my hat, that's my home. Also, make sure you tell them that missing a credit card payment not only means you have to pay twice as much next month, it also means that any mortgage application within a year of missed payments may run into difficulty. And by difficulty, I mean it may cost you an awful lot of interest because we'll have to go to a specialist lender who will charge 2 or 3% more. Shared ownership. This is a good way for the young and not so young to own their own home. Basically, they purchase a share in a property and a housing association owns the rest. The owner pays rent on the mortgage they don't own. If the value of the property is $200,000, they're buying 40% of it. The deposit required is based on the purchase price of the share, i.e. $80,000. Some lenders apply the rate on the cost. So if the deposit is $8,000, they get the 90% mortgage rate. Other lenders apply the rate on the total value, and then you get the 36% rate. Well, they don't go down that low, but you'd certainly get the 75% rate, which makes it massively cheaper. So, as I say, a good way for someone to own their own home, or at least part of it. Smaller deposit, much lower mortgage amount in payment. Don't forget there's still rent to pay. Once they purchase the property in this way, they can buy an increased share, and this is called staircasing. The housing association will agree what the price is to buy the extra share. Protection. Our specialist subject. In the simplest form, this is house insurance. If a flat is purchased, the building's insurance is usually arranged by the owner of the block of flats and it's charged as part of the service charge. Contents insurance is still needed. If it's a house, then the owner is responsible for the building's insurance. The lender is no longer allowed to insist that the owner has buildings insurance, but I have to say that anyone who owns a house and has no insurance is quite frankly crackers. If a house has been destroyed by a fire and no insurance is in place, then they will have nowhere to live, no money to rebuild it, yet they'll still have a mortgage to pay. Oh yes, and if it was your gift that enabled the house to be bought, well, that's gone up in smoke too. I have a working knowledge of these things, but if you contact me, I'll be able to briefly explain, but I would also be able to put you in touch with a really good insurance broker who would be able to go through it much better than I would, as it's their specialised subject. Now, I know a lot about life insurance. If someone purchases a property with their partner, what do they want to happen if they die? If it's hoped that it will be a long-term relationship, then surely they want to know that their partner can continue to live in the property if they die. Similarly, what happens if one of them suffers a critical illness? If that happened, say a heart attack and lived, there may be a time when they have no income. Would you like the mortgage to be cleared if that was to happen? It may also be the case they can't use the stairs anymore and need to build an extension. So use some money for the extension and the rest to pay off the mortgage. My view is that everyone purchasing a property in joint names should have a minimum of life insurance to cover it. I would also say critical illness makes sense. We're talking about youngsters. We're talking about the cost of life cover being £5 and the cost with critical illness maybe being 20. Well, if they can't afford 20, then how the hell are they going to afford the £1,200 mortgage? If they're buying in sole names, I would suggest income protection so they receive an income if they're unable to work through ill health. They have little need of life cover as no one is dependent on their income. Student loans. Go on then. Student loans, how many does it affect? Isn't it terrible, all this debt they get saddled with? It's my public service talk for this week. It's quite surprising, really, how many people do not understand how these work and what they are, really. So, the old Victorian adage, neither a lender nor a borrower be. Outdated, isn't it? I fear that not all debt is bad. Let's face it, we're here talking about houses. How else would you do it? Save. Same for buying a car. But not all debt is good. There's very little good about a payday loan. Now, can we agree what a loan is? To me, if I borrow a lot of money, at the outset, the lender tells me what the interest rate is, how much the payment will be, and how long it will last. The higher the interest rate, the higher the payment. Lovely, simple, we all understand. So if you borrow £1,200 over a year at 5%, the payment's 105. If the rate's 10%, it's 110. I've been shot. Sorry, got a page missing. When you have a student loan, if you go to university and you come out with a loan of £60,000, interest is charged depending on the amount that you borrow. If you earn £25,000 or less, it's 3.3%. If you earn £45,000 or more, it's 6.3%, and it goes up pro rata. So if you earn £30,000 a year, you pay 4.05. How much do you have to repay? If you earn £25,000 or less, you pay nothing. If you earn £25,000 or more, it's 9% of the excess. So if it's £30,000 that you earn, and you've got to pay 9%, the payment is, John?
£450.
That's right. So you've got a £60,000 debt, and you pay £450 a year. If someone does a more complicated degree, a veterinary surgeon, 7-year course, not good pay when you start, they come out with a £100,000 debt, the payment is
£450.
the same. You've got the same income. So you pay £450 on a £100,000 debt. Is this mad? Yes. So what are we worried about? We all think that student loans have this effect. With the interest rate, when I picked 60,000 as the amount, I didn't realise it was going to work out this way. But if your income increases from 25,000 to 30,000, the rate increases by 0.75%. Your payment's 450, and strangely, 0.75% of 60,000 is also 450. So your payment that your child is now making doesn't reduce the debt. You're only really paying the increase in interest. You're still not covering the rest of the interest. After 30 years, the balance of the £60,000 mortgage for the student that earns 30,000 is, I hope you took your Valium this morning, £197,265. Why did he laugh? Because it's written off. So you've paid £450 for 30 years, £13,500. And with addition of all the interest and everything else, the government at a stroke go, well, that's that done. So is it really a loan? I've never had a loan where they did this. It'd be good if they did. I always have to pay all the interest. So the interest doesn't affect the payment. There is almost no chance it will be repaid. So is it really a loan? Or is it, should we perhaps think of it as a, 9% extra tax? I think they would talk of doing a graduate tax instead of student loans. So please, if you ever hear someone saying, I've just inherited some money from my nan who died, and I'm thinking of paying some off my student loan, the answer is, don't do it. Please, don't let them do it. They're just wasting their money. This is not a millstone. It's an opportunity for a child to go to university, get a degree, see a bit of life, hopefully get a good job, and yes, they will have to make payments. But so many people get degrees and don't earn fortunes and potentially will never pay any money. So I've gone over, strange idea, you probably thought I was going to talk about gifts, savings, how mortgages work, what your children need to do to be in a state where they can borrow money so that the lender's happy, they can find them electronically. And student loans, please, don't worry about them that much. Best place to check this isn't, surprisingly, a .gov website. Go to the Martin Lewis website. I can't remember what it's called, but if you Google Martin Lewis, he'll come up. And in there, he will explain everything you need to know about student loans. And you'll be happy to know that's it from me. So now, Surjit will lead you through all the technical stuff.
Right, thank you, Dennis. As you all know, I'm Surjit, and I advise on all areas of family law, including divorce, finances, children matters, cohabitation, prenuptial agreements and cohabitation agreements. But today I'm going to be talking to you about cohabitation and property ownership. I'm just going to grab my... Right, so now you've had your advice from Dennis, we're now purchasing our house. So I asked my 6 and 8-year-old to build me a house. They either ran out of Lego pieces because they didn't build an upstairs, or they just told me it was a bungalow. And we've got John and Jill in the house at the moment. So 5 words, common law husband and wife. Is there such a thing? So I'm going to start with a case study. So John purchases a house in 2011. He purchases it in his sole name using a deposit made up of his own money and a mortgage with a high street bank, again in his sole name. He starts to live in it, and 1 year later he meets Jill in a pub. They begin dating, they stay out over at each other's houses, and Jill is renting a 1-bedroom flat. But after a while, they think it's pointless that Jill is paying all this rent when she's spending so much time at John's house. So she gives up her flat and she moves in with John. They lived together from 2013 until 2017, and then unfortunately, they break up. During the time that they were living together, all the bills for the house were in John's name. Jill had a cat, which she bought with her. She paid for the cat food. She paid for meals out, trips away, and contributed some cash for purchasing some of the food. John and Jill did not have any specific conversation about whether or not Jill would obtain a share of the property. So after 4 years of living together, does Jill have a potential claim for an interest in the property? No, she doesn't. Would your answer be any different if there had been a specific conversation where John had promised Jill a share, although he was very vague about it and not very specific? But there'd be, or if there'd been no specific conversation and they'd got engaged, would your answer be any different? No. So Jill had joined with John on the bills, including the council tax, the gas, electricity, water, broadband. Would the answer be any different? No. So Jill's flat had been very convenient for her work. She'd given up her tenancy which she could have extended to a further 2-year fixed term, but she didn't. She moved in with John. So also that didn't make any difference. They opened up a joint bank account and their wages were paid into that joint bank account and the mortgage debits were taken from that. Is there an interest there? Possibly. So if John and Jill did have a specific conversation and he then, next Valentine's Day, sent her a card which looked like this, would she have an interest? At this point, I would be getting a little bit nervous. So the answer is no, there is no such thing as a common law husband and wife. This is a myth. So keeping on with our couple of John and Jill, had John and Jill been married, the answers would have been very different. With married couples, in the event of a separation, the starting point is equality, irrespective of whose name is on the title deeds. And there are various factors which are considered when determining whether there should be departure from a 50-50 split. However, cohabitees do not have the same rights to make property claims as married couples. So the common law husband and wife does not exist. Right, so moving on to who has an interest in the property and what is an interest. So an interest is a term used when your name is on the title deeds. So if your name is on the title deeds, this is a legal interest. So I'm going to also be using the term beneficial interest. However, with beneficial ownership, your name is not on the title deeds, but you have an interest in the economic benefit of the property. I'm going to be referring to tenants here, but that doesn't mean that I'm referring to rental properties. Tenants is a terminology used within property ownership. So there are two straightforward ways in which you can acquire an interest in the property. So going back to John and Jill. Do you want to come over? So if they decided to purchase the property together, this can be purchased as joint tenants. So if they're purchasing as joint tenants, they own all of this together. So what that means is they will hold the property as a whole, and if John was to die, his share would automatically pass to Jill. Or, however, if they decided to buy as tenants in common, John and Jill would hold their separate shares. So John would hold this side and Jill would hold this side.
Unequal shares.
Yeah. Right, so what is the difference between joint tenants and tenants in common? Yeah. So as tenants in common, you have equal rights to the whole property. The property automatically goes to the other owner if you die, and you can't pass on your ownership of the property in your will. As tenants in common, you can own the property in different shares. The property doesn't automatically go to the other owner if you die. You can pass on your share of the property in your will. So an example of this is, again, going back to John and Jill. They've purchased a property in joint names. They've not specified when they purchase the property that it will be held any differently than in joint shares, and there's no declaration of trust. So Kate will be talking to you further about declarations of trust. The legal title says John and Jill. They buy the property for £65,000 using a £12,000 deposit. They make unequal contributions to the deposit. John pays £3,000, Jill pays £8,000, £5,000 of which has come from her parents. John also meets the legal fees. The mortgage is in joint names. They each put their money into a joint bank account. John is self-employed, so he can't put in as much as Jill, and he contributes 40% to the mortgage, but as and when he can contribute more, he does. And Jill pays 60%, and they equally contribute to the household bills. So they separate after 21 years, and they've got 3 children. So Jill says, hang on a minute, I've contributed way more to this property than you have over the years. However, they both sign the transfer document when they purchase the property, and therefore this would be conclusive of their interest, irrespective of the contributions that they've made, because they purchased the property as joint tenants. So the important message here is that when parties are buying a property, it must be explained about the different ways that a property can be held, as this can make all the difference in the event of a separation or one party's death. Therefore, it must be explained to parties that the beneficial ownership mirrors the legal ownership, and it is very difficult to prove otherwise. So a property can also be held, as we explained, as tenants in common on our little model with the separate shares. So John and Jill have both paid £15,000 each to purchasing a property, but they each want to respectively hold their shares. So as with the model I showed you, they're going to hold it as tenants in common in equal shares, and that is conclusive of their interests. And as long as they've been to see Kate to have a will drawn up, their share will pass to whoever is named in their will. So if they'd contributed unequally to it, and Jill had put in 20 and John had put in 10, they would then hold the property in unequal shares. They would have a declaration of trust drawn up, which Kate will tell you more about, and that will be conclusive of their shares as unequal shares. With joint owners, what you have to remember is that equity follows the law. So if you buy as joint tenants, irrespective of what you have contributed, this is conclusive of your shares. So where it gets a little bit more complicated is where a property is bought where a property is purchased in one party's sole name. So in our scenario, it's purchased in John's sole name. So Jill has no legal interest in the property, but she says, I've been living there for X amount of years, and therefore I should have an interest in this property. Otherwise, why would I have moved into this property and contributed to this property? So Jill decides to go off and take some legal advice. So she would be advised by me in this scenario that she would need to establish that she has got a legal interest in the property. It's not just automatic because she's been living in this property. So what I would be advising Jill on here is, firstly, express trust. So this is an example of this is, did John expressly say that he was holding the property for both of them, despite the title being in his sole name? This is an express trust because a specific conversation would have taken place between the parties, but if she was to issue a court application to establish her interest, she would need to be very specific about when the conversation took place, the nature of that conversation, and it would come very much down to the evidence that the parties give. So an implied trust, this is when no conversation took place between the parties, but you would be looking at how the parties' conduct may suggest that Jill has an interest in the property. And this is broken down into a resulting trust and a constructive trust. So a resulting trust will arise when a person can show that they have made a direct financial contribution to the acquisition of the property. So when I mean a direct contribution here, I'd be talking about a contribution towards a deposit, mortgage, any renovation works that were carried out. It does not mean a contribution to bills, shopping, etc. So if Jill had made a direct financial contribution towards the mortgage, she could argue that she has an interest in the property, even though the property is in John's sole name. She would be saying that by making her contribution, there was a common intention to hold the beneficial interest in the parties, in the property, in the proportions to the contributions made by the parties. So with a resulting trust, there's a contribution made by the parties. However, if she'd not made any contribution, then she could rely upon a constructive trust. This is when you are reliant upon an agreement between the parties. So either by conversation, which took place, or actions, such as the card that John gave to Jill on Valentine's Day, or the fact that she could have project managed some renovations that took place in the house. So it would be very much dependent on the actions of the parties if you were going to rely upon a constructive trust. And finally, proprietary estoppel. This is saying that John has led Jill to believe that she has a beneficial interest in the property. And there are 3 ingredients present with proprietary estoppel. Firstly, a representation is made or an assurance is given to the non-owning party. Secondly, there is a reliance on that assurance. And thirdly, some detriment is incurred as a consequence of that reliance. She could say that she'd moved out of her own flat and not renewed her own tenancy. She could rely on that. It's extremely challenging to establish an interest in a property where it is in the sole name of your cohabitant or former cohabitant. And whilst it may be a struggle for Jill, and she could be successful, it's a long and expensive process if a court application does need to be issued. And court applications of this nature would be issued with extreme caution. So what should Jill have done in these circumstances? Jill should have thought about having a cohabitation agreement drawn up. So what is a cohabitation agreement? A cohabitation agreement is a signed written document, often signed as a deed in front of witnesses. It will deal with three principal areas: who owns and owes what at the time of agreement and in what proportions, what financial arrangements you've decided to make while you are living together, and how property, assets and income should be divided if you split up. So in order to avoid any dispute, the agreement would need to be properly drawn up, the terms would need to be reasonable, and you would both need to take independent legal advice so that a court is more likely to uphold the agreement in the event of a dispute. When should I make a cohabitation agreement? A cohabitation agreement can be made at any time, whether you're about to start living together or if you've been doing so for many years. There's no time when you make a cohabitation agreement. And why should I make it? A cohabitation agreement should be made. So as I've said previously, cohabitants do not acquire the same rights as married couples. So if cohabitants split up, there are no set of rules that automatically applies as it does in marriage, where there is a starting point is equality. What would you cover in a cohabitation agreement? You could cover your shared home, how this is owned, whether there has been any separate agreement or promise that isn't currently reflected in the legal documents, who is paying the mortgage, if there are any endowment policies or other saving arrangements linked to a mortgage, what contributions are being made, and what will happen if you split up. You can include in there money and paying bills. Most people find it convenient to have a joint bank account when they live together, but they need to decide what contributions would be made into that joint account. Will there be equal contributions? Would you use your separate accounts for other things? How much will be paid towards the household bills? You can also include in there things about your personal possessions, such as furniture, cars, so that there is no dispute when you do, in the event that you do separate. So just to throw something else into the mix, John and Jill have now broken up. It wasn't too acrimonious because they had a cohabitation agreement, but John has now met Penny. So Penny's not up for the idea of just living together and wants a ring on her finger because she's a bit more traditional. So they're getting married in 3 months' time, and Penny had won the lottery before meeting John and also has 2 children from a previous marriage, Anna and Elsa. So she wants to protect her winnings, as she'd use this to buy a castle, which she wants to leave to her children. So they're going to have a prenuptial agreement drawn up, and John is so in love with her that he's happy to enter into this. Prenuptial agreements, what are they? A prenuptial agreement is a legal agreement made between 2 individuals before their marriage has taken place. The agreement between John and Penny will set out how they would want to divide their assets if they later divorce. It can also provide details of how they would want to arrange their finances during their marriage. So prenuptial agreements, as many of you may have heard, are not legally binding in the UK, but there are several cases now which do support prenuptial agreements. But there are certain conditions which need to be met to give the agreement compelling weight, which are: it's important that the agreement is not considered to be unfair. So you couldn't have an agreement in these circumstances which did not provide anything for John if Penny had all the wealth. So even if you were to have a staged agreement, so if they separated after a period of time, John would get X amount out of the settlement. There would have to be fairness within the agreement. Otherwise, it would not be upheld. The agreement must also be made following full financial disclosure. So each party has to know about each other's financial assets. You must both take independent legal advice, and the agreement must be entered into free from duress or undue influence. And finally, it must be signed at least 28 days before the wedding. It cannot be signed the day before the wedding, because then it could be said that it was signed under duress. So it must be at least 28 days before the wedding. So in summary, and I know there's some estate agents and financial planners in the room, and you're likely to be the first port of call when there is a property purchase. So my advice would be that with what I have discussed today, it should be brought to the attention of clients so that they do have the opportunity to take legal advice. If legal advice is not taken, then cohabitants can find themselves in protracted court proceedings, which can not only be extremely lengthy, but also extremely costly. and in circumstances, the losing party would not only be paying their own costs, but also the losing party's costs. Thank you.
Okay, well thank you Sergit, and good morning everybody. My name is Kate Middleton and I am a private client solicitor at the Thurrock office of Palmer's. So what do? I am a registered trusts and estates practitioner under STEP, which is the Society of Trusts and Estates Practitioners. I'm also an accredited solicitor for the elderly. My day-to-day work involves advising people in respect of their wills and estate planning, as well as advising in relation to lasting powers of attorneys and court of protection matters. People often ask what court of protection matters are. That is, court of protection get involved where someone has lost capacity but hasn't put a lasting power of attorney in place, and court intervention is required to decide who should act on somebody else's affairs. My other main areas of work include dealing with estates, obtaining grants of probate, and also dealing with declarations of trust, advising in relation to shared ownership of property. So following on from our very informative talks from Dennis and Sergit, I'm now going to talk a little bit about declarations of trust, which I believe I go that way. Yeah. So we've already heard from Sergit about some of the issues that can arise with cohabiting couples and situations where a cohabitation agreement might be advisable. What I'm going to talk about is declarations of trust, and although some of the aspects covered in a declaration of trust can also overlap with what's covered in a cohabitation agreement, they are actually different agreements, though sometimes it is appropriate to have both at the same time. What does a declaration of trust do? A declaration of trust usually records the proportions that parties have put into a property and dictates how that property or those proceeds of sale would be divided when the property is sold. So those most commonly used by cohabiting couples, they, along with a cohabitation agreement, they can be used when you're purchasing, for example, an investment property. You might be purchasing it with a friend or a relative, but because there's no intention to live in that property or cohabit with that person, you don't need a cohabitation agreement, but the declaration of trust would be the document that sets out what you've agreed in relation to ownership of that property. Are they legally binding? Yes, they are, provided that they are correctly executed and that they comply with the relevant formalities. They'll be binding on all parties to the document. This is in contrast to cohabitation agreements, which have faced some difficulty in the past. It is important to note, though, that in line with what Sergit has discussed as well, declarations of trust can be overturned by the court. So if circumstances have changed, so for example, if a couple make a declaration of trust, they subsequently get married and then divorce, that could potentially be a situation where it would then be overturned by the courts. We've still kept on the theme of John and Jill. So this is John and Jill. They've agreed to purchase a property. They're purchasing it as tenants in common, as Sergit discussed. 75% is being held by John and 25% is being held by Jill. They've decided to put a declaration of trust in place to specify that these are the shares that they're going to hold in the property. They then decide to get married, because who doesn't? And then they decide to have children and a dog, and I think there might be a cat there, I'm not quite sure. So if they then divorce, the declaration of trust would be looked at by the courts, and actually it might well be that because of the circumstances that have changed, the courts would decide that actually the declaration of trust that they made in the first place is they're going to overturn it, and they're actually going to award Jill a larger share. So although the divorce courts are not automatically bound by a declaration of trust, it doesn't mean that they will always overturn. So it really does depend on the circumstances. What do declarations of trust include? Well, there isn't any one answer to this because they can be either as simple or as complex as the parties require. And so it will often depend, again, on the circumstances. So just to mix things up a bit, I'm going to introduce two new faces, and this is Bill and Ben. And Bill and Ben are two friends from university, and they have decided that unlike some of Dennis's clients, these two are going to be sensible, and they're going to purchase an investment property together rather than spending all their money on coffee and beer. So Bill is contributing £45,000 to the deposit, and Ben is contributing £25,000 to the deposit. They're funding the rest by mortgage, which Dennis has kindly arranged for them. And they agree the following. The mortgage will be redeemed first. Well, that's not something they agree. That's something, funnily enough, the mortgage company insists on. Ben would then take Bill would take £45,000, Ben would take £25,000, and the remainder they're going to split 50-50 between them. This would be recorded by way of a simple declaration of trust. They don't wish to specify any further terms, and they're not intending to live together, so there isn't a requirement for a cohabitation agreement. However, at the same time, Bill and Ruby are purchasing a property together. So Ruby is Bill's girlfriend, and they've decided that they'd like to move in. They're buying a property for £500,000, and as Bill has already invested a large amount of money on his investment with Ben, he's only able to put £15,000 in. Ruby is putting in £35,000, and the rest they're funding by a mortgage. But they're going to split this mortgage 60%, 40%, because Bill is a higher earner than Ruby, so he's going to pay a slightly higher percentage of the mortgage. So a declaration of trust has been prepared, setting out the following. The mortgage will be redeemed first. Bill is going to receive 3%, and we'll come back to that. Ruby is going to receive 7% or £35,000, whichever is greater. The remainder is going to be split 60% between Bill and 40% to Ruby. They're contributing to all the bills equally, and Ruby has the option to buy out Bill. The value of the property, if they were to split up, is to be done by a chartered surveyor from the Royal Institute of Chartered Surveyors. So obviously this is a bit more of a complex situation from the situation of Bill and Ben, and there are some issues to consider. I would point out at this stage, Ruby is the one that has had this declaration of trust prepared. An important thing to note with declarations of trust, when we're advising as solicitors, we can only advise one party in relation to that declaration. So even though our conveyancing team may be acting for the couple jointly purchasing the property, in relation to a declaration of trust, we can only advise one party. So, some issues raised from the declaration of trust that Ruby has had prepared. Firstly, you may have noted that Bill's investment has been represented, his £15,000 has been represented as a percentage. This means that if the property prices go up, his percentage increases, so he would get a better return on his initial investment. If the property prices go down, he will potentially get back less than he has originally put in. Now, that wouldn't necessarily be a problem if Ruby and Bill were both being treated the same. They would both benefit if it went up, they would both lose out if it went down. But Ruby has actually protected herself against this, as she stipulated that she gets either 7% or her initial £35,000, whichever is greater. As they're contributing to the mortgage in unequal shares, they've decided to split the remaining equity to reflect that. Ruby's also included a provision in there that she has the option to buy Bill out. That's not particularly uncommon. Generally, there would probably be an agreement that either party can buy out, but sometimes the situation is that one party would never be in a financial position to buy the other out, and one might be included over the other. But from this point of view, we know that Bill is actually a higher earner than Ruby, so there isn't any particular reason why he should be excluded from being able to buy Ruby out as well. And again, when it comes down to having the property valued, this is down to the parties to agree how they want the property to be valued and stipulating whatever they've agreed within the agreement. They might say they only want it to be by one estate agent, and they might have a particular estate agent or they might have a particular estate agent that they don't want to value the property. For example, if Ruby's dad happened to be an estate agent, then perhaps Bill wouldn't want to agree to that being the only way the property's valued. They could choose that it's 3 valuations and they take the average of the 3, or they could say they want it by a chartered surveyor to get perhaps arguably a more accurate valuation. So as you can see, declaration of trust is there to set out what parties have agreed at the beginning of entering into an agreement to purchase a property together. Rather than waiting for everything to fall apart and then try and fight about it at the end, it's far better to put a declaration of trust in place at the time when everybody's happy in an agreement. It's much easier to sort these things out at the beginning than it is to sort them out at the end. So just a couple of other points to note in relation to declarations of trust before we move on. Sergit discussed joint ownership, but also property purchasing in a sole name. So declarations of trust are not just for joint owners. Somebody owning a property in their sole name can also create a declaration of trust to show that they're holding either whole or even, part or even whole of the property on trust for somebody else. An area where this used to be common was in relation to right to buy properties. The parents were entitled to purchase their property under a right to buy scheme, and in the height of that era it was more common that actually the children out-earned their parents. I think they say that this is our generation, or the millennial generation is one of the first generations where it's actually flipped round and that the parents are financially better off. So what used to happen quite commonly was actually the parents got the ability to purchase a right to buy property, but they didn't necessarily have the funds, didn't perhaps want to take a mortgage. So the children offered to lend them the money, and then that was protected, their interest was protected by a declaration of trust setting out that that's how the properties were held. Finally, declarations of trust aren't fixed. They can be updated. So, for example, with our scenario of Bill and Ruby, if Ruby came into some inheritance from an aunt and paid £50,000 off of the mortgage, she would perhaps want that to be reflected within the declaration of trust because she's then invested a larger share. So provided that they're in agreement to that, that declaration can be updated to reflect any changes. So, moving on. Firstly, can I have, now this is where I really get to see the interesting things, can I have a show of hands for everyone in the room that's made a will? Oh, that's quite good. Secondly, for those of you who have made a will, can you keep your hand in the air if you've reviewed it or made it in the last 5 years? That's still fairly good, but at least I've got a good idea of who I need to speak to afterwards. Just a few statistics before we move on, because let's face it, who doesn't love a statistic? You did well in this room, actually, because just around 60% of UK adults don't have a will. 42% of over 55s don't have a will, and shockingly, 70% of cohabiting couples don't make wills. So, why is it important to have a will? A will allows you to take control. So it allows you to choose who your executors are. It allows you to appoint guardians of any children that you might have. They do have to be minors. You can't appoint people to look after your adult children. It allows you to decide how your assets are distributed. It allows you to protect certain people's interests, i.e. if you're in a second marriage and you've got children from a first marriage, you might want to ensure that they're protected in some way. And it also allows you to balance out lifetime gifts. So say you've made a lifetime gift to one of your children, you've perhaps lent them or given them money for a deposit, but you haven't done that for the other one yet, maybe because they're not in that position. But you might want to balance that gift out within your will, and the will enable you to do that. So I could talk about wills, the need to have wills and the need to keep them updated all day long. But luckily for you, I think we've got about 10 to 8 minutes left, in which time I'm going to try and stick to our theme of the Bank of Mum and Dad and look about how the various interests that we've already discussed today, along with some new ones, can be protected by making a will. I would like to stress though that everyone should have a will, although today we're talking about it largely in relation to people owning property in unequal shares and cohabiting couples. Doesn't matter, everyone should have a will. So just a little bit about the format of a will. A will should be in writing, validly executed. That means it should be signed by the testator or testatrix, and that's the person making the will. It should be witnessed by 2 independent witnesses, and a key thing is all 3 of those people have to be together in the room at the same time, witnessing each other's signatures. They should have mental capacity. You can't make a will if you don't have mental capacity. This is something that comes up quite a lot, and I'm often surprised by the amount of people that aren't aware that when you get married, it will revoke a will that you've made unless you have made that will in contemplation of marriage. And I have actually had clients that have fallen foul of that, where they made a will, got married, spouse died, they didn't realise that the will had been revoked. Divorce, on the other hand, only partially revokes your will, but it does revoke the important bits. So it says that if you've appointed your spouse as executor and you've given anything to your spouse within your will, if you divorce, they are deemed to have predeceased you. So they are deemed to have died at the date of divorce, basically. But it's still important to keep your will up to date. I don't think I'd be wanting to rely on a will that was pre a divorce. So moving on, just to identify some key issues that clients have concerns on in relation to joint ownership and making a will. I'm going to go back to some of our couples. So firstly, I'm going to go back to John and Jill. So having dispelled the myths of common law husband and wife, it's important to consider how your property will pass in the event of your death. So just an update on John and Jill. I know in Sergit's scenario they divorced and he went off with Penny, but we're going to put them back together. They've been married for 25 years and they have 2 children, James and Julia. They've long since sold John's original property and they now own their home jointly as tenants in common. As this was how they'd held their previous property, they thought it was a good idea to continue doing that. The property's worth $750,000 and they have given their eldest child, James, £50,000 deposit for a house. So why is it important that John and Jill make wills? Well, to dispel another myth, if your spouse predeceases you, they don't automatically get everything. And it took me a long time to convince my mum and dad that they needed wills because they thought that that was the case. So if you die without making a will, something called the rules on intestacy apply. And for married couples like John and Jill with children, this is what would happen. Jointly owned assets pass automatically. So that could be joint property, joint bank accounts. But as we discussed with Sergit at the beginning, a property held as tenants in common passes, your individual share passes in accordance with your will. So it won't automatically pass to the survivor. Your personal chattels, everyone always says to me, what's my personal chattels? It's your bits and bobs. Generally, they would pass to your spouse automatically, and then only the first $250,000 would pass. The remainder, if there is anything remaining, is then split 50% between your spouse and 50% between any children. So running through the scenario of John and Jill, what would Jill receive? Obviously, she owns her half of the property already, but in respect of John's, she would receive his personal chattels. She'd receive £250,000. She'd then receive half of the remainder, which is $62,500. James would then receive $31,250, and so would Julia. Now, this isn't what John and Jill want. John and Jill have decided to make straightforward wills, leaving everything to each other. However, they want to ensure that their children are treated equally, and as they've already made a gift of £50,000 to James during their lifetime, they want to ensure that there is a clause within their will which allows this to be balanced out. So on the death of the survivor of them, Julia would receive a specific gift of £50,000, and the remainder would then go equally between James and Julia. This way, John and Jill have been able to balance out what they wanted to do. Now, these wills, that's not a complicated will by any stretch, so hopefully that just illustrates the importance of making a will. Wendy.
Are there any tax implications on gifting an amount of money to children?
So it
No.
largely,
No, if it's a gift.
Right.
So if you give £100,000 to your child, it's a gift. They don't pay income tax.
they don't pay tax, but from your point of view,
Yeah.
there might be tax implications depending on the overall value of your estate. Basically, a gift during your lifetime comes under what they call a PET, which is a potentially exempt transfer. So provided, if you make a gift, provided you're not retaining a benefit over that gift and you then survive for 7 years after that, that gift falls out of your estate for inheritance tax purposes. There are other complications around it, but generally that's...
Clive.
If I may, a common concern of mums and dads, including this dad, is that you very generously from your family fortune provide that deposit to your loving daughter, who is not intending to get married but is going to cohabit with her loving boyfriend. But of course it doesn't last. And as
If you have your way.
said, you don't want him to have it. So
Yeah.
what is the best way, accepting what Dennis told us earlier on, that the mortgagee is going to be saying, let me know, Dad, that you're surrendering your interest in that. Of course, you're going to sign a letter to say that you are.
that you're gifting, yeah.
Really, when that breakdown happens, you don't want that awful young man to run up with part, if not all of your family
Yeah.
fortune.
You do that with tenants in
Do-
common ownership, wouldn't you?
Yeah.
You would make sure that your daughter, say if you gave her £500,000, Clive, then the first £500,000 would be your daughter's, or half a penny. But the first portion would be your daughter's, and then maybe 50-50.
Are they buying in joint names? Would they be buying in joint names?
Sorry, this is a little fictitious.
Yeah.
Right, okay, so-
So it could be any situation, but it's the thing which links.
I think really in that situation, I think what you're looking at is joint ownership as tenants in common, with a declaration of trust setting out what shares they own, marrying that with wills that then protect how that interest then passes. Because obviously if they do the declaration of trust, get married, don't update their wills, then obviously depending on the values that we're talking about, then that could be passing to the spouse, whereas the will would be where they would direct it back to you, in effect, if something happened in that scenario.
Also, one of my questions was how do you prevent, if you do all this in advance, currently I have a daughter that's single,
Mm-hmm.
we make the gifts and we do that properly, and then the interloper comes along, and then it all goes pear-shaped. How do you protect your interest, or more importantly, how do you protect your daughter's interest? Or thirdly, how do I not sponsor this interloper for the rest of their life?
This is the part where we said life is ever more complicated and gone are the days of...
I didn't include it in my talk because I didn't want to get bogged down with this lender does that lender does this. But as you brought the topic up, Santander currently allow the maker of a gift to have a second charge on the property. So although they will sign to say, oh, it's not a loan, it's not going to be repaid, I'm not having this, and I won't have an interest in the property, they allow the second charge so that in your specific example, when your daughter meets this interloper, then if it's sold, Santander's mortgage will be repaid first, your mortgage will be repaid second, and then it's...
And then it would be...
So then you put an RX1 or whatever, what is the
Yeah.
instrument that's about?
Yeah, well, if the charge is registered anyway, that would go on there automatically. But yeah.
Tenants in common, and you could determine what
Yeah, your mortgage will rank
Before that.
any other agreement. So first mortgage, second mortgage. Well, I used to work in a bank, so first mortgage, second mortgage, third mortgage, fourth mortgage, fifth mortgage, then the will. Then,
Or declaration
then
of
the
trust.
declaration of trust. But yeah, you'll be second mortgage, so you'll get paid before anyone else. Well,
Okay.
after them, before anyone else.